Welcome to CM Guide podcast series. Today, we're embarking on a deep dive into something that can often feel like a puzzle in the building world. The building and construction industry security of payment legislation, specifically here in Victoria, Australia. If you're involved in construction from the biggest developers right down to the smallest subcontractor, or maybe you're just genuinely curious about how payments are protected in this absolutely vital industry, well, this deep dive is for you.
Yeah.
We're going to peel back the layers, understand its origins, how it actually works, and what it all means for anyone navigating the intricate world of building projects.
That's exactly right. At its heart, this legislation, which, we'll often call the VIC Act, it's really about making sure that those who actually do the work, particularly folks further down the contractual chain like subcontractors and suppliers, they actually get paid and get paid promptly. It's fundamentally about maintaining healthy cash flow, in an industry that really forms the backbone of our economy. We'll dig into how Victoria's specific laws have developed, their unique twists and turns, and why understanding them isn't just like a nice to have. It's pretty much a necessity for financial stability.
Okay, let's unpack this then. We constantly hear about payment disputes in construction, don't we?
Yeah.
And the impact, it can be devastating for businesses. So what was the real problem the VIC Act was trying to solve? Was it simply about fairness, or was there something more systemic going on?
Exactly. Historically, the construction industry has been, kind of notorious for its complex web of contracts. You've got your principal contractor, then layers upon layers of subcontractors and countless suppliers all connected. The issue really was that those lower down the chain, they were incredibly vulnerable to payment delays or sometimes worse, outright non-payment. Just imagine a small electrical contractor, right? They've finished their work, they're waiting months for payment, or maybe even facing insolvency because a larger firm upstream just refuses to pay. This kind of ripple effect could devastate entire supply chains.
Wow.
So the VIC Act, officially the Building and Construction Industry Security of Payment Act 2002, it was brought in to tackle this systemic vulnerability really head on. It kicked off on January 31st, 2003, and its core objective, much like similar laws across Australia, was basically to set up a rapid interim adjudication process for progress payments, designed to keep money flowing down that chain without massive delays or getting bogged down in long legal battles.
Okay.
It was really about creating a statutory right, a right to immediate payment for work done.
So it definitely sounds like a response to a very clear industry problem. But the VIC Act didn't just sort of appear out of nowhere, did it? What's its background, its lineage, and why did Victoria choose to introduce it when it did? Was it a completely new invention, or did it, look elsewhere for inspiration?
Oh, it definitely wasn't conjured out of thin air. Not at all. The VIC Act was significantly modeled on legislation from New South Wales. Specifically, the Building and Construction Industry Security of Payment Act 1999 from New South Wales.
Oh.
And this wasn't just accidental copying. It was a very deliberate strategic choice. The Victorian Minister for Planning at the time, Mrs. Delahunty, made this clear during her second reading speech. The main goal was to ensure that building firms operating nationally across state lines could have common payment requirements across both Victoria and New South Wales.
That makes sense.
Yeah, it brought a significant benefit. Just imagine a company, right, working on big projects in both Melbourne and Sydney. Without that commonality, they'd face completely different rules, different timelines, different procedures for every single payment claim.
A nightmare.
Exactly, an administrative nightmare. So that initial alignment, it was all about creating a more streamlined, predictable, and consistent legal landscape, especially for those larger players operating across state lines, reducing their admin burden and, legal complexities.
That makes perfect sense for businesses spanning state borders. But I get the feeling Victoria didn't just copy it word for word and leave it at that. Where did the VIC Act start to sort of diverge from its New South Wales and Queensland counterparts? What makes it stand out? And why did it end up carving its own distinct path?
Yeah, you've absolutely hit on a critical distinction there. While the VIC Act shares the same fundamental goal and, the basic processes as the New South Wales law, it pretty quickly distinguished itself. It had some unique provisions right from the start. The Victorian Supreme Court, for example, adopted a noticeably different, quite independent approach to interpreting these unique bits, particularly around its role in supervising and reviewing adjudication determinations.
Interesting.
So while courts in New South Wales and Queensland are still definitely looked to for some guidance, Victoria really did forge its own path, especially when it came to challenging those payment decisions. And then a major evolution happened in 2006. The Building and Construction Industries Security of Payments Amendment Act 2006. This amendment, it aimed to make the legislation even more effective, in securing prompt progress payments, really empowering those doing the work.
Right.
But it also marked a significant departure from the New South Wales model. It introduced the exclusion of certain types of claims from the Act's scope. That's something we'll need to dig into. It's quite unique to Victoria.
Okay, excluded amounts. Got it.
Exactly. And it also set up a system for adjudication review, which is another distinct Victorian feature. And just very recently, actually February 2024, the Vic Act saw another targeted tweak to Section 49. This change essentially beefed up the power of the Victorian Building Authority, the VDA. It allows them to use and disclose information gathered through the Act for their registration and disciplinary actions against registered building practitioners who fail to pay adjudicated amounts.
So adding more teeth to enforcement.
Precisely. It shows an ongoing effort to strengthen the whole enforcement mechanism and, ensure people actually comply.
So we're talking about a mechanism really designed for speed.
Yeah.
And what about that famous phrase we often hear kicked around in this context, pay now, argue later? How does that principle actually apply here in Victoria, and what's its real significance for someone, say, a subcontractor trying to get paid? It sounds almost revolutionary, frankly.
Oh, it is. That principle is absolutely central, and yes, it is revolutionary for many in the industry. The pay now, argue later mechanism is fundamental to the Vic Act, just like it is in New South Wales and Queensland. What it really means is this. Once an amount has been formally adjudicated as due, it must be paid quickly.
Right.
Even if the paying party, often the principal contractor, fully intends to dispute that amount later on, in more formal, probably lengthy litigation or arbitration. The entire spirit of the Act, it's geared towards prompt resolution, keeping that cash flow healthy within the industry. And it explicitly tries to minimize excessive legal formality and technicality, at least at this interim payment stage.
So cutting through the red tape, essentially.
That's the idea. The judges have often noted that the Vic Act champions freedom from unnecessary technicality. It shows a really pragmatic drive to provide a swift, unburdened process for resolving these interim payment disputes. And this principle, it dramatically shifts the power balance in construction.
How so?
Well, historically, the scales were often tipped pretty heavily in favor of principals over subcontractors, right? They could just withhold payments or drag out disputes for months, maybe even years, using their greater financial strength as leverage.
Yeah, I can see that.
The pay now, argue later principle fundamentally empowers those who actually carry out the work, the subcontractors, the suppliers. It gives them the power to recover their progress payments without undue delay. For many in the industry, this is a massive aha moment because it provides a statutory right, a legal right, to immediate payment for work they've done, regardless of whether there's some other more complex, simmering dispute about the overall contract terms or performance. It effectively decouples the right to get paid for specific work from those broader, often very protracted contractual disputes, which, let's face it, can be incredibly long and costly. It's all about ensuring money flows when the work is done, preventing smaller businesses from collapsing just because payments are being withheld.
Okay, so how does this powerful pay now, argue later mechanism actually get started? I imagine it all kicks off with some sort of formal payment claim, right? And you mentioned something called reference dates. It sounds like getting the timing absolutely spot on is critical here.
Exactly. The reference date is the absolute linchpin. It's the trigger for when a payment claim can even be made under the Vic Act. And you are spot on. Getting these dates precise is absolutely critical because a misstep here, it can invalidate your entire claim under this specific process.
Right.
The Vic Act has a, let's say, rather complex arrangement for calculating these dates. Now, if your construction contract does specify a reference date, then that's what you follow. That governs. It takes precedence. But if a contract doesn't make express provision for a reference date, if it's silent, the Act defaults to a specific schedule. It says the reference date will be 20 business days after the previous reference date. For the very first claim, if the contract is silent, the first reference date is 20 business days after work first started.
Okay, 20 business days.
Yep. And the Act even includes specific rules for calculating a reference date when a progress payment is just a single one-off payment or maybe a final payment. The importance of getting these dates right, honestly, it cannot be overstated. A slip-up here can render an entire claim invalid for the purpose of adjudication under the Act. We saw this really vividly in a case called Hallmark Construction v. Seville.
What happened there?
Well, in that particular contract, there was no provision for calculating reference dates, so the default rules in the VIC Act applied. Justice Vickery, based on new evidence, carefully worked out when the work was actually last carried out. And his crucial finding was that both payment claims they were looking at were, quote, hopelessly out of time when measured against these statutory reference dates.
Hopelessly out of time.
Wow. Yeah. And as a direct result, the adjudication determination that had been made based on those claims, it was deemed void, kaput. This case really highlights why paying extreme attention to these statutory time limits is just paramount. For any party looking to use the VIC Act to get paid quickly, it's a foundational piece. If you miss the boat on the reference date, your claim might not even, get off the ground using this quick mechanism. It's like missing the tax deadline. You might still owe the money, but you can't use that specific streamlined process anymore.
That truly sounds like a potential minefield, just getting the timing sorted. Okay, what about the actual content of a payment claim then? Especially when it comes to changes in the work, variations. I understand the VIC Act has this unique concept called claimable variations. What exactly are those and why are they so significant and, from what I'm hearing, potentially so complex?
Right. This is precisely where the VIC Act introduces some notable complexity that really sets it apart from other Australian security of payment laws. Now, a variation in a construction contract, it's simply defined as a change in the scope of work or the goods or services to be supplied under the contract. Pretty standard.
Okay.
The Act lets contractors claim for all payments under the original contract sum naturally, but it meticulously specifies which variations actually qualify as claimable variations for the purpose of a payment claim under the Act, and crucially, which ones don't.
Okay, so not all variations are equal in the eyes of the Act.
Exactly. The unique and, frankly, quite intricate classification of claimable variations is laid out in Section 10A of the VIC Act. Now, this section, it's fair to say, has copped a fair bit of criticism for its sheer complexity, even from judges. Oh yeah. It provides a highly complex statutory scheme outlining which classes of variations can be taken into account when calculating a progress payment under the Act. Broadly speaking, there are two types. The first type is an agreed variation that's usually straightforward enough, where both parties have signed off on the change.
Makes sense.
The second type, though, that's where the significant complexity kicks in. A disputed variation for work that's already been done. For these disputed variations to be considered claimable under the Act, specific conditions have to apply. The main condition is that the contract sum, at the time the contract was signed, must be $5 million or less. Or, alternatively, there must be no dispute resolution clause written into the construction contract itself.
Okay, $5 million or no dispute clause.
But wait, there's more. Here's where it gets really tricky and where people often get tripped up. There's a crucial caveat. If, at any point, the total amount of claims for disputed variations adds up to more than 10% of the original contract sum.
10%, okay.
Then the specific claim that pushes it over that 10% threshold and all subsequent claims for disputed variations after that point will not be considered claimable variations under the VIC Act. Now, this 10% cap applies if the original contract sum was over $150,000, unless, again, there's no dispute resolution clause in the contract.
Wow, that is layered.
It is. It's a lot to digest. And this complexity hasn't gone unnoticed by the judiciary. There's a notable judicial comment on Section 10A that perfectly sums it up, and I'll quote it directly. It takes several readings to digest the steps required, and several more steps combined with a respectable prowess in the science of numbers to apply it. Although the confounding formula on a close reading is tolerably precise, it fails in the critical task of communicating the legislative stipulations in a user-friendly and readily comprehensible fashion.
So even the judges find it tough going.
Exactly. That quote is a real aha moment, I think. It highlights the very real practical challenges of navigating these rules without, pretty extensive legal help. It's a provision designed to be precise, sure, but its practical application for people on the ground is anything but simple. It's like a beautifully engineered but incredibly complex machine. Powerful, yes, but really hard to operate without the full instruction manual and maybe an engineer standing next to you.
Okay, so beyond these mind-bending variations, are there other types of claims you simply cannot bring under the VIC Act? You mentioned excluded amounts earlier. Sounds like another unique layer of things to watch out for. What are these exactly, and why does Victoria have them when other states apparently don't?
Yes, this is indeed a unique feature of the VIC Act. You won't find excluded amounts in the security of payment legislation in places like New South Wales or Queensland. Excluded amounts are specific types of claims that an adjudicator is expressly forbidden by law from considering when making a determination.
Right, forbidden.
Yep. And if an adjudicator does accidentally consider an excluded amount, their determination becomes void, legally invalid, but only to the extent that it included that excluded amount. This is critical because it fundamentally limits the scope of what the Act can actually achieve for someone making a claim.
Okay, so what sort of things are excluded?
The VIC Act defines them quite clearly under Section 10b. They include any amount related to a variation that is not a claimable variation, tying back directly to that complex Section 10a we just wrestled with. So if your variation doesn't meet those Section 10a criteria, you can't claim it via adjudication. Simple as that.
Got it.
Any amount other than a claimable variation claimed under the contract for compensation because something happened, an event. This specifically includes amounts relating to latent conditions and like a hidden, unforeseen problems on site.
Like hitting unexpected rock.
Exactly. Or time-related costs, like claims for delays caused by the principal or costs arising from changes in regulations. Any amount claimed for damages for breach of contract, or any other claim for damages arising under or connected with the contract. So basically, you can't use this Fast Track Act for claims for general damages like lost profits because the other side breached the contract.
Right, that sounds more like traditional court stuff.
Precisely. Any amount related to a claim arising at law other than under the construction contract itself. So if your claim isn't directly tied to the specific construction contract, it's out. And finally, any amount of a class that might be prescribed by regulations as an excluded amount, though that's less common.
And why? Why exclude these things?
The main rationale given is that these types of claims are often attended with considerable complexity and speedy resolution can be an elusive goal. The thinking is that these claims are just too intricate, too nuanced, or too much like traditional lengthy court cases to be resolved quickly and summarily through the streamlined adjudication process. So the VIC Act basically says these amounts must not be included in payment claims, or in the calculation of progress payments, or in adjudicator determinations, or even in an adjudication review. They are simply kept outside the Act's fast-track mechanism. And importantly, a big case, Seabay Properties Purdy Limited v. Galvin Construction Purdy Limited, clarified that this list of excluded amounts in the Act wasn't necessarily exhaustive. And crucially, it held that even liquidated damages, those pre-agreed penalties for delays, were also an excluded amount.
Even liquidated damages, wow.
Yep. The court also made clear these exclusions apply to claims made by both parties, claimant and respondent. Now, this whole raft of exclusions, it's fair to say, has been blamed in legal commentaries for contributing significantly to the VIC Act's complexity, and maybe, as a consequence, leading to a relatively lower adjudication usage rate compared to states like New South Wales and Queensland, because it means many common types of construction claims just can't be pushed through this mechanism. It's a really fundamental difference to grasp because it seriously limits the scope of what the Act can actually do for a claimant. It's like building a fast-track highway, but then deciding certain types of vehicles, like trucks carrying complex loads, aren't allowed on it.
Okay, that makes sense. So if a payment claim is made and the respondent disputes it, they typically issue a payment schedule, right, outlining their reasons. But does Victoria allow the respondent to then introduce brand new arguments at the adjudication stage, even if those arguments weren't in that initial payment schedule? That feels like it could definitely catch a claimant off guard, almost like a surprise tactic.
Yes, this is another pretty significant difference, and you're right, it can indeed be a point of contention and potentially surprise for claimants. Unlike its counterpart in New South Wales, the VIC Act does allow a respondent to include additional reasons in their adjudication response, reasons that were not included in their initial payment schedule. Yes, it's quite a unique provision, maybe designed to give respondents a bit more flexibility. Now, if this happens, new reasons pop up, the adjudicator must serve a formal notice on the claimant, clearly setting out these additional reasons, and then the claimant gets 2 business days to lodge a response, specifically addressing only those new reasons.
2 days isn't much time.
It's tight. And this mandatory process, it has been looked at by the courts. particularly regarding questions of procedural fairness. Is it fair to spring new arguments late in the game? In a case called Metacorp Limited v. Endeco Construction Group, Justice Vickery provided some clarity. He essentially said that even though the Act sets out this 2-day response process, the underlying common law rules of procedural fairness still apply. They sit alongside the Act, meaning there might be situations where just giving those 2 days isn't enough to be fair. Specifically, if the claimant's response to the new reasons raises a new matter of fact or law that hasn't really been discussed before by the parties in the document submitted, and if that new matter is truly important, truly material to the decision the adjudicator has to make.
Ah, okay.
So while the Act gives the respondent this flexibility to add new arguments, the adjudicator still has that fundamental duty to ensure procedural fairness overall. This might mean they have to give the claimant another chance to comment if really new, game-changing issues are introduced that go to the core of the dispute. It's a bit of a delicate balancing act, trying to prevent ambush while still aiming for prompt resolution. But yeah, it adds another layer of dynamic interaction and potential complexity to the adjudication process here in Victoria.
That is a lot of detail to get right. From those complex reference dates and variations to excluded amounts and now the possibility of new arguments appearing late. What are some of the other absolutely critical timing and procedural requirements for making claims and applying for adjudication under the VIC Act? It really sounds like precision and sticking to strict deadlines are just completely essential here.
Precision is absolutely paramount. You've nailed it. The VIC Act is just riddled with precise time limits and procedural steps that you must follow meticulously for both a payment claim and an adjudication application to be valid. Missing these deadlines or steps can easily be the death knell for your claim under this specific act.
Okay, lay them out for us. What are the key ones?
All right, let's break down some of these critical timelines because they can be quite fiddly. First, the payment claim itself. If your contract doesn't specify a time limit, it must be served within 3 months after the relevant reference date. 3 months.
3 months after the reference date. Okay.
Then, once a payment schedule is received from the respondent, if the claimant decides, right, I need to adjudicate this, the adjudication application has to be served within 10 business days after receiving that payment schedule. Or, alternatively, if the respondent scheduled an amount but hasn't paid it by the due date, the application must be served within 10 business days of that payment due date.
10 business days. Tight.
Very. Now, what if no payment schedule is provided at all? Which does happen. The process gets a bit more involved. The claimant must first give a formal notice of their intention to adjudicate. This notice has to be given within 10 business days following the original due date for payment.
Okay, a notice first.
Yes, and this notice acts as a crucial second chance for the respondent. It gives them precisely 2 additional business days to issue a payment schedule. If they still don't provide one after that 2-day window closes, then the claimant's adjudication application must be served within 5 business days after that 2-day second chance period expires. It's a very specific sequence you have to follow.
Right. Notice 2 days, then 5 days.
Got it. For the adjudicator themselves, once they have all the submissions, they typically have 10 business days to make their determination. However, they can extend this period by up to 15 business days if the claimant agrees. The Act actually says the claimant must not unreasonably withhold their agreement for such an extension.
Okay.
Another procedural point. If a construction contract happens to list 3 or more authorized nominating authorities, or ANAs, those are the bodies that appoint adjudicators.
Right.
The claimant actually gets to choose which one of those listed ANAs they submit their application to. So that gives the claimant some control over who might ultimately appoint their adjudicator.
Interesting.
And just a practical note for the modern age, email can be used for serving both payment claims and adjudication applications, which certainly streamlines the process compared to the old days of registered post for everything.
That's helpful.
Definitely. Beyond these strict timings, recent court decisions in Victoria have also clarified several other important points, often bringing Victoria more into line with other states. For instance, it's now firmly established that a payment claim served before its reference date is invalid for the purpose of the VIC Act.
Don't jump the gun.
Exactly. That was a welcome change from some earlier Victorian thinking and aligns us with New South Wales and Queensland. Also, critically, a claimant is not required to act in good faith or genuinely believe their claim is totally accurate for it to be valid under the Act. The Act focuses more on the process and the form, not the claimant's subjective state of mind. Furthermore, the payment claim absolutely must clearly identify the construction work it relates to. Vagueness can make it invalid. And while serving an adjudication application slightly outside the time limits doesn't automatically void the determination, the adjudicator might still have jurisdiction, remember that a premature payment claim itself does render it invalid from the get-go.
So many potential pitfalls.
There are. These detailed requirements really underline the critical importance of meticulous administrative work and often legal advice to successfully navigate the VIC Act. It truly is like following a complex recipe, miss one crucial step, or misread a measurement, and the whole dish might just not turn out right.
So after an adjudicator makes a decision, is that the absolute final word? Or does Victoria, unlike many other places it seems, offer yet another layer of review for those determinations?
It sounds like there are potentially multiple avenues for challenging a decision, which I guess could add more complexity again.
Yes, this is indeed another major differentiator for the VIC Act, and it definitely adds a distinct layer to the process.
Yeah.
Unlike most other Australian jurisdictions, Victoria, along with Western Australia, actually introduced what's called an adjudication review scheme.
Okay, adjudication review.
Exactly. This means that either party, claimant or respondent, can actually apply for a review of the original adjudication determination. But this review is done by a second adjudicator, who is specifically referred to as the review adjudicator.
A second bite of the cherry? Sort of, but a very limited bite. The mechanism for this is set out in sections 28B and 28C of the Act. The review adjudicator gets appointed by the very same authorized nominating authority, the ANA, that appointed the first adjudicator.
Okay.
However, and this is crucial, this review is quite limited in its scope. It can only be made on one specific ground: that the original adjudicated amount wrongly included an excluded amount. Remember those complex items we discussed earlier? The ones the adjudicator isn't supposed to consider.
Right, the latent conditions, breach of contract damages, etc.
Exactly. That's the only basis for review. And for the review to even be triggered in the first place, the original determination amount must exceed $100,000.
$100,000 threshold. Why that amount?
Well, that monetary threshold was specifically set, according to the parliamentary debates, to protect smaller subcontractors. The idea was they rely heavily on prompt payment and shouldn't be dragged into potentially complex review processes for smaller sums where the cost and effort might outweigh the benefit.
Makes sense. Are there other conditions?
Yes, there are strict conditions for applying for a review. A respondent can only apply if they specifically flag the amount as an excluded amount in their initial payment schedule or their adjudication response. They have to raise it earlier. And they must have already paid the adjudicated amount to the claimant. Except for the portion related to the alleged excluded amounts, that specific disputed bit gets paid into a designated trust account.
So they still have to pay most of it first.
Yes, the pay now principle is largely upheld even during a review. Now, a claimant can also apply for review, but only if they believe the adjudicator wrongly decided an amount was an excluded amount, thereby stopping it from being included in the original determination when it should have been.
Okay.
And critically, a review adjudicator is generally bound by the findings of fact made by the first adjudicator. Their job isn't to rehear the whole case or reevaluate the evidence. It's primarily just to correct errors specifically related to those excluded amounts and make sure the first adjudicator stayed within their proper legal boundaries.
So it's a very narrow review focused just on those excluded amounts.
Precisely.
Okay, given this internal review system then, can parties still choose to go straight to the Supreme Court for judicial review? Or does the VIC Act try to sort of funnel everything through this internal review process first, aiming to keep these disputes out of the higher courts? It feels like there could be a bit of tension there between the Act's mechanism and the court's power.
That's a really important question, isn't it, about the interplay between these statutory schemes and the inherent powers of our courts? And the answer is yes, they can still go to the Supreme Court. Both the initial adjudication determination and the subsequent review determination are, in principle, open to judicial review by the Supreme Court.
Oh, okay.
And interestingly, the Victorian Supreme Court has, in practice, accepted applications for judicial review, even when this internal review scheme was potentially available to the parties. This suggests that parties seem to have a degree of discretion, a choice, about which avenue to pursue.
Why would they bypass the internal review and go straight to court? Is there an advantage?
Well, there are often strategic considerations, particularly for a respondent, the party who has to pay. Under judicial review in the Supreme Court, the respondent typically only has to pay the unpaid adjudicated amount into court as security for costs, rather than paying it directly to the claimant right away.
Ah, so they hold on to the money longer.
Essentially, yes. The only exception is for those alleged excluded amounts, which, as we said, must still go into a trust account, just like under the adjudication review scheme. So, choosing judicial review can be a tactical decision to avoid immediately releasing the bulk of the funds to the claimant while the challenge is ongoing. It lets them keep their money, albeit tied up as security with the court.
Right.
However, you're right about the tension. The fact that the court entertains these direct applications rather than perhaps insisting parties use the internal review first might seem a bit inconsistent with the whole intention behind putting the adjudication review scheme into the VIC Act in the first place, which was presumably to offer a quicker, cheaper internal remedy. It's particularly noticeable when you compare it to how courts in Western Australia, which has a similar internal review scheme, tend to operate. They typically look less favorably on granting a discretionary remedy, like judicial review, if an alternative statutory remedy, like the internal review, was available, but the party chose not to use it. It really highlights that ongoing balance in the legal system between purpose-built statutory processes and the fundamental right to seek review from the higher courts.
Fascinating. So the courts do have a role, and clearly a significant one, in overseeing this whole process. What exactly is the scope of that judicial review? How far can the Supreme Court go in picking apart an adjudicator's determination? And has their approach remained consistent over the years, or has it shifted?
The Victorian Supreme Court has indeed played a very significant role in clarifying the scope of judicial review, and yes, its approach has certainly evolved over time. Initially, believe it or not, there were actually very few applications challenging adjudicator determinations here in Victoria. It took a while to gain traction. Yeah. But then key cases like Hickory Developments v. Ciavello and Grocon Constructors v. Planet Cocciardi Joint Venture were pivotal. These cases basically established that adjudicator determinations are, in principle, amenable to court orders like certiorari for errors of law.
Okay, certiorari. Remind us what that means again.
Sure. Certiorari is essentially a court order that quashes or legally cancels a decision made by a lower court or tribunal if that body acted outside its legal authority or made a fundamental error of law apparent on the face of the decision. Think of it like a referee making a call that's completely outside the rules of the game. The higher court can step in and overturn it.
Gotcha.
Now, this position evolved significantly, particularly after two major decisions, the High Court's decision in Kirk and the New South Wales Court of Appeal's decision in Chase. These landmark cases across Australia confirmed that certiorari is available if adjudicators commit what's known as jurisdictional errors.
Jurisdictional errors, meaning
They act beyond their legal power or jurisdiction granted by the Act, or if they breach a fundamental condition required by the Act for a valid determination. This led to a reconsideration of a previous Victorian approach that had seemed to give adjudicators quite broad power to decide their own jurisdiction. The courts clarified that if there's a challenge to the jurisdiction the adjudicator assumed, it ultimately has to be determined by the court, based on facts found during the judicial review process, not just based on what the adjudicator themselves decided.
Okay, so the court has the final say on whether the adjudicator had the power to decide.
Exactly. And more recently, in a case called Radman v. Open Plan, Justice Digby provided even more clarity on the precise scope of judicial review in Victoria. He stated quite clearly that the legitimate grounds for judicial review are limited to specific types of legal errors, such as jurisdictional error, lack of procedural fairness, and material error of law on the face of the record. That gives a pretty clear, tight framework for when the courts will actually step in.
So, jurisdictional error, procedural unfairness, or obvious legal mistake.
That's the essence of it. Building on this, Justice Vickery, in another important case, Max Strestra Constructions BD Limited v. Gilbert, reviewed a whole lot of previous Supreme Court decisions and helpfully summarized 4 key established legal principles about judicial review under the VIC Act. 1. First, yes, an adjudication determination is open to judicial review for those fundamental legal errors acting outside jurisdiction or making a clear legal mistake obvious from the determination itself.
Okay.
Second, a court declaration that a determination is invalid is only available if the absolute basic, essential requirements of the Act for a valid determination haven't been met, or if the adjudicator's decision wasn't a genuine attempt to exercise their power under the Act, or if there was a really substantial denial of natural justice, meaning a party just wasn't given a fair hearing.
Right, fundamental flaws.
3. Third, these basic requirements or essential preconditions are essentially what we mean by jurisdictional errors. They're the things the adjudicator must get right to have the power to make a valid decision. And fourth, importantly, granting these court remedies like certiorari or a declaration of invalidity is always at the court's discretion. They aren't automatically given, even if an error is found. The court considers all the circumstances.
Okay, that's a helpful summary.
Yeah, and beyond those core principles, the Victorian courts have issued heaps of other rulings that really fine-tune how the Act works in practice, offering crucial insights for everyone involved. For instance, it's not just any tiny typo that invalidates a payment claim. The courts have clarified it needs to be a substantive defect, a major flaw, not just a minor slip-up.
Right.
However, as we said, a payment claim served before the reference date is invalid. That's a definite hard line now. Claimants are not required to act in good faith or have a bona fide belief in their claim. The focus is purely on the process and the objective facts. The payment claim absolutely must clearly identify the construction work. And interestingly, a person or company already in liquidation cannot use the Act to compel payment.
Ah, that's important for insolvency situations.
Very. Also, an adjudicator making a valuation without strictly following the methods set out in the contract, if there is one, can be a jurisdictional error. This extensive body of case law really shows how the courts have shaped the practical application and day-to-day understanding of the VIC Act, clarifying its boundaries and ensuring procedural fairness within its unique framework.
Let's pivot now to a specific and, let's be honest, often contentious issue in construction contracts: retention money. How does the VIC Act treat claims involving money that's been withheld by the principal as retention? This is a huge concern for subcontractors, isn't it, who often see significant chunks of their cash flow tied up in these funds for long periods.
Yes, it absolutely is a major issue, and this area saw some significant and I'd say very welcome clarification for subcontractors not too long ago. There was an important case called Hunters Green Retirement Living Plety Ltd v. J.G. King Project Management Plety Ltd, and it delivered a pretty definitive ruling. Claims for the return of retention monies do qualify as payment claims under the VIC Act.
Ah, so you can use the Act to chase retention money.
Yes. The court found what it called a direct and obvious nexus between the retention monies withheld and the construction works that had been performed. This connection made these claims valid and actionable under the rapid adjudication process of the Act.
That sounds like a big win for subcontractors.
It really was. This decision is highly significant because it effectively superseded quite a few previous court authorities that had held that a payment claim made solely for the return of retention money was not a valid payment claim for construction work or related goods and services under the Act's definitions. So this ruling brought much-needed clarity, and it aligned the treatment of retention claims much better with the Act's overall purpose, which is ensuring payment for completed construction work.
So what does that mean practically for, say, a builder listening now?
Well, what it means for you, the subcontractor or builder, is a clearer, faster statutory path to recovering those funds that principals have withheld as security, usually for potential defects or incomplete work. Once the contractual conditions for the release of that retention are met, you can use the VIC Act's payment claim and adjudication process to pursue those sums if they aren't paid. It removes a major historical hurdle and provides a statutory pathway to chase these often quite substantial amounts of money.
Right. Good to know.
It's also important, though, to differentiate retention money from other forms of security that might be used in contracts. Things like security bonds or bank guarantees, those are treated differently. They aren't generally considered deductions from payments for construction work in the same way retention is, so they don't typically fall under the same payment claim mechanisms of the Act. That distinction is crucial for understanding what you can and cannot pursue using this specific legislation.
Okay, retention, yes. Bank guarantees, no. Got it. Now, beyond the claims themselves, who actually regulates the adjudicators and the bodies that appoint them, the ANAs you mentioned? Is there a system of oversight to ensure fairness, competence, and impartiality in this really crucial process? Or is it a bit of a free-for-all?
Oh, no, it's definitely not a free-for-all, thankfully. There absolutely is robust oversight in place, and it's critical for maintaining the integrity of the system and ensuring people actually trust it. The VIC Act itself, specifically Section 43, gives power to the Victorian Building Authority, the VBA, to impose strict conditions on both the authorized nominating authorities, the ANAs, and also directly on the adjudicators themselves. And these conditions are established in accordance with detailed ministerial guidelines, ensuring a consistent standard across the board.
Okay, so what sort of conditions are we talking about for the ANAs first?
Right. For the ANAs, there are formal authorized nominating authorities conditions of authorization. These set out a really comprehensive range of obligations. They cover everything from their general professional conduct, maintaining strict confidentiality and privacy, to providing public access for advice, meticulous management of the whole adjudication process itself, robust record keeping and reporting requirements, and critically, establishing a comprehensive complaint system.
Raw complaint system.
Yes. This complaint system has to be independent, ensure complaints are resolved in a timely manner, and offer appropriate remedies and sanctions when a complaint against the ANA itself or an adjudicator they nominated is actually proven. This ensures accountability for these bodies that are essentially the gatekeepers of the adjudication process, making sure they maintain high standards and are responsive to issues.
And what about the adjudicators themselves? Are there standards for them too?
Absolutely. There are specific adjudicator standards of conduct that they must adhere to. These standards guide their behavior and performance when they're carrying out their functions under the VIC Act. They cover general obligations, probity, which means integrity and honesty, competence, and crucially, conflict of interest. On that point, adjudicators must not accept appointment to a case if doing so would create any actual or even likely conflict of interest or bias on their part. That's a complete non-negotiable.
As it should be.
Exactly. The standards also cover procedural fairness, confidentiality, and rules around their fees. And importantly, they must only accept nominations if they genuinely consider themselves competent for the specific nature and complexity of the particular matter they're being asked to decide. It's all about ensuring impartiality, technical expertise where needed, and ethical conduct in every single determination.
Right.
And finally, the ANAs also have a responsibility to ensure that the adjudicators they nominate actually meet specific adjudicator core competencies. This includes things like having recognized qualifications, a minimum number of years of relevant industry experience, and detailed training requirements, including ongoing continuing professional development or CPD.
Okay.
So yeah, there's quite a multi-layered regulatory framework in place, designed to ensure that the entire adjudication process, right from the initial nomination of the adjudicator through to their final decision, is handled by competent, impartial, and ethical professionals. It's a really significant safeguard for the overall fairness of the process.
That's reassuring to hear. Okay, what happens then if, despite all that, an adjudicator's determination is challenged in court and is found to be invalid? Maybe they made one of those jurisdictional errors we talked about. Can parts of the decision still be saved? Or does the whole thing get tossed out and everyone has to go back to square one? It sounds like a potentially massive waste of time and money if an entire determination is simply voided.
That's an excellent question, and it really speaks to the need for efficiency and practicality in how the courts handle these challenges. The Victorian Supreme Court has actually adopted a pretty flexible approach here, even though the VIC Act itself is actually silent on the concept of remittal.
Remittal.
Remittal means sending a case back down to the original decision maker, in this case the adjudicator, for them to reconsider it in light of the court's findings. Despite the Act not explicitly mentioning this power, the court has done it in several cases. And often, they remit the matter back to the original adjudicator who made the flawed decision.
Back to the same person.
Well, the reasoning, as explained in cases like Plenty Road v. Construction Engineering, this Stuth, is primarily to avoid unnecessary delay. The original adjudicator is already fully across the case, right? They've read all the submissions, considered the evidence. Sending it back to them promotes a central aim of the Act: minimizing delay and getting these payment disputes resolved. So while a determination might be quashed by the court because of a specific legal error, the court often prefers to send it back to the same person who's already done most of the heavy lifting, rather than forcing a complete fresh start with a brand new adjudicator who would have to begin from scratch. It's pragmatic.
Okay, that makes sense, saving time.
Exactly. And in addition to remittal, Victoria, unlike some other jurisdictions, also accepts the legal proposition of severance.
Severance, like cutting out the bad bits.
Precisely. It means separating the valid parts of an adjudicator's determination from the invalid parts. So if only a specific portion of the adjudicator's decision is found to be legally flawed, the court might be able to sever or cut out that invalid part and leave the rest of the determination legally intact and enforceable.
Oh.
However, as we saw in that Maxter Constructions v. Gilbert case, this isn't always practical or possible. If, for example, the adjudicator missed a fundamental factor in their overall valuation of the work, changing that one element might affect the entire calculation, making severance impossible. In that situation, the whole valuation part might need to be remitted. But in other cases, like one called Gauntly Pleady Limited v. Phoenix International Group, the court found that severance did operate effectively and actually achieved the act's purpose by preserving the valid parts of the decision. It really demonstrates the court's pragmatic approach, trying to fix what's broken without having to demolish the whole structure if it's not absolutely necessary.
This has been a truly comprehensive look at how the VIC Act operates, warts and all, as they say. So, thinking about the big picture, how effective has it actually been in practice? What do the usage rates tell us? Is it truly helping to secure payments for those who need it most? Or is it perhaps still seen as too complex or difficult to use effectively?
Yeah, the VIC Act's usage rates, they've had a really interesting journey over the years. It reveals quite a clear evolution in how it's been adopted. You see, from when it started back in 2003, right up until about June 2011, the usage was actually surprisingly low, averaging only about 71 adjudication applications per year across the whole state.
Only 71. That seems tiny for the amount of construction work.
It does, doesn't it? It suggests that for its first roughly decade, it wasn't widely embraced, or perhaps, as you say, it was perceived as too complex, or maybe just not fully understood by the industry as a primary tool for resolving payment disputes quickly. However, since around 2011, there's been a really significant and quite rapid increase in the use of the regime. For instance, just looking at the 2022-2023 financial year, Victoria saw 384 adjudication applications lodged, which was a notable jump up from 324 in the previous year.
Okay, so a definite upward trend.
Absolutely. These stats now make the VIC Act the second highest in Australia in terms of the sheer number of applications lodged each year, putting it right behind New South Wales, which traditionally has the highest volume. We also saw a shift in the average value of the amounts being claimed. It went from about $358,000 in 2021-22 down to around $193,000 in 2022-23.
Interesting. What does that suggest?
Well, it could suggest that perhaps more claims, potentially involving smaller average amounts, are now being brought through the system. Maybe smaller players are getting more comfortable using it, or maybe it's being used for more routine progress payment disputes rather than just the really big ones.
Right.
But despite this growth, it's probably fair to say that Victoria's popularity for this security of payment regime is still relatively lower than New South Wales and Queensland, especially when you consider the sheer volume of construction activity happening in Victoria.
And why might that be?
Well, it could be attributed to a couple of the key factors we've already dug into. One major reason is likely the existence of those excluded amounts in the VIC Act. As we highlighted, that limits the types of claims that can actually be adjudicated here, making the Act less comprehensive than some of its interstate counterparts.
Right.
The other significant factor is almost certainly the overall complexity of the regime itself. Navigating those intricate rules, particularly around reference dates, claimable variations, and those tricky excluded amounts, it often requires quite specialized legal assistance, which can make it a more challenging and potentially more costly process for businesses, especially smaller ones, to use effectively without getting professional guidance. So you could say it's effective for those who manage to master it, but the learning curve is undeniably steep.
Okay, that leads us perfectly to the future then. It definitely sounds like there's acknowledged room for improvement and perhaps simplification. Are there any current efforts underway to reform the VIC Act, to address some of these complexities or perceived shortcomings that might be holding back its usage or effectiveness?
Absolutely, yes. There's a very strong push for reform happening right now, and it looks like significant changes are probably on the horizon. It's true that the VIC Act hasn't seen really substantial amendments since that big overhaul back in 2006, unlike its counterparts in New South Wales, WA, and Queensland, which have been updated more frequently. But significant reform now looks very likely for Victoria.
What's driving that?
Well, in early 2023, the Victorian government launched a parliamentary inquiry. It was led by the Environment and Planning Standing Committee, and this committee was specifically tasked with thoroughly evaluating the existing payment protections in the industry and suggesting improvements, with the core objective always of ensuring subcontractors get paid promptly for their work.
Okay, an inquiry. What came out of it?
In November 2023, the committee released a really comprehensive report, and it contained 28 specific recommendations, all aimed at improving the effectiveness of the adjudication process and addressing those concerns about perceived inequities and inefficiencies in the current system. And these proposals are quite extensive. They directly tackle many of the complexities we've spent the last while discussing today.
Right. Can you give us some highlights? What are the big potential changes?
Sure. Some of the really key proposals include abolishing excluded amounts and non-claimable variations. This is probably the biggest one. It would dramatically simplify payment claims and significantly broaden the scope of what can actually be adjudicated in Victoria, removing a major point of unique complexity compared to other states.
That'd be huge. What would it mean for listeners?
Well, for you, listening in, it could mean that disputes that currently get stuck in traditional, often slow and expensive court proceedings, things like those tricky delay cost claims, or arguments about unforeseen site conditions, latent conditions, could potentially be resolved much faster and cheaper through adjudication in the future. That's a massive potential saving in time and legal costs.
Definitely. What else?
Replacing reference states, they're proposing a move towards a much simpler one payment claim per month system and allowing claims even after the contract has been terminated. This would massively streamline that initial claim process, making it far less of the minefield we talked about earlier.
Yeah, that sounds much simpler.
Amending the business day definition, specifically to exclude the period between December 22nd and January 10th each year. This just aligns the act with the common understanding of the Christmas-New Year holiday shutdown period, preventing parties from being inadvertently time-barred just because businesses are closed or running on skeleton staff. Prohibiting unfair contract clauses. This is a big one for fairness, particularly for subcontractors. It would give adjudicators, courts, or arbitrators the power to declare certain contract clauses, like harsh time bar clauses, unfair, and therefore unenforceable if compliance was impossible or just unreasonably difficult. It also aims to generally prohibit other types of unfair construction contract clauses, giving more protection to the typically weaker party in negotiations.
Interesting. Power to strike out unfair terms.
Yes. Extending time limits. They recommend extending the time limit for claiming payment to 6 months after the work related to the claim was last carried out, or even longer if the contract allows for it. This gives claimants more flexibility and breathing room.
6 months, okay.
Setting upper payment due limits, capping payment terms at a maximum of 25 business days after a claim is made. This is designed to prevent principals from imposing excessively long payment terms in contracts, which can really strangle cash flow for businesses down the chain.
Right, stop those 60 or 90-day terms.
Exactly. Clarifying retention money entitlement. Putting the position on claiming retention money beyond doubt, essentially solidifying the principles from that Hunter's Green case we discussed, ensuring clarity for subcontractors. Preventing new reasons in adjudication response. This is a big procedural change. They recommend reversing the current Vic Act approach, bringing it into line with New South Wales. So respondents wouldn't be able to introduce completely new arguments in their adjudication response if they weren't in the initial payment schedule. The idea is to stop claimants being blindsided, promotes clearer, more focused dispute resolution.
Okay, no surprises.
Removing the adjudication review mechanism. Since the review mainly deals with excluded amounts, its usefulness is being questioned, especially if excluded amounts are abolished anyway. Getting rid of it would simplify the potential appeal process. Modernizing notice service, fully embracing electronic methods like project management software, lockboxes, and email for serving official notices, just reflecting how business is actually done these days. Mandating continuing professional development, CPD, for both adjudicators and the ANAs, ensuring they maintain ongoing competence and stay up to date with the law in this rapidly evolving area.
Good idea.
Protecting ANAs. Extending civil liability protection to the ANAs themselves, similar to the protection adjudicators already have. This is to ensure they can perform their crucial duties without facing undue personal legal risk, including adjudication fees and certificates, ensuring that successful claimants aren't left out of pocket for the respondent's share of the adjudication fees if they win, making the process fairer financially. Enforcing certificates as judgments, streamlining the compliance process by allowing adjudication certificates to be filed directly with the court and enforced as if they were court judgments, making it much faster and easier to get paid.
That sounds very efficient.
And finally, reviewing trust schemes. Considering introducing cascading deemed statutory trust schemes or specific retention money trust schemes, this is a big potential change aimed at further protecting subcontractor payments, especially against the risk of upstream insolvency, which is a massive concern in the industry right now.
Wow, that is a comprehensive list of potential reforms.
It really is. And considering the extensive nature of these recommendations, the clear ongoing demand for reform in Victoria's system, following not just this inquiry, but also a previous nationwide review, and sadly, the recent spate of construction business insolvencies, combined with the government's generally active legislative efforts in the construction industry. Well, it seems highly probable that many of these recommendations will actually be implemented in the relatively near future.
So we could be looking at a significantly overhauled Vic Act soon.
I think that's highly likely, yes. An act that could potentially be much more user-friendly, more efficient, and ultimately, hopefully, even more effective for all parties involved in the construction supply chain here in Victoria. It really feels like a sign that the system is continually trying to adapt to better serve the needs of the industry.
Wow, that was truly a deep dive into the Victorian security of payment legislation. My head's spinning slightly with all the detail. But from this New South Wales roots, through all its unique, sometimes pretty complex, features like excluded amounts and adjudication reviews, and now looking ahead at some potentially really transformative recommendations for the future. It's just so clear this area of law is constantly evolving, isn't it?
It really is.
It just underscores the critical, sometimes absolutely life or death role these payment protections play in the overall health and stability of the entire construction industry.
Absolutely. And understanding these intricacies, these nuances we've talked about, it isn't just about legal compliance ticking boxes. It's genuinely vital knowledge for anyone operating in the construction sector here in Victoria, whether you're a principal contractor trying to manage projects and cash flow, or a subcontractor relying on those timely payments to keep your own business afloat. And the ongoing push for reform, it really highlights that even with the best intentions, there's always a journey towards creating a fairer, more efficient system, one that ensures everyone gets paid properly for the work they do, which ultimately fosters a healthier and more stable industry for absolutely everyone involved.
And ultimately, for you, our listener, grappling with this stuff, this knowledge isn't just academic, is it? It's really about empowering you to navigate the real-world, day-to-day challenges of payments and construction. Maybe pause and consider, how might these proposed reforms, if they happen, impact your current contracts or your approach to future projects? What specific payment terms in your existing agreements might suddenly become classed as unfair under new legislation? And how would you need to adapt your own practices, your own contract administration, to stay compliant and ensure you're protected? Food for thought.
Definitely.
Before you go, please don't forget to share, like, or subscribe. Also, have a look at other episodes and visit CM Guide website for better insights on this topic.